Okay, let's talk about Virginia Circuit Courts. I clerked a while back in Norfolk Circuit Court. This is one of their this is in the new courthouses, and one of their courtrooms, which they spread out the jury box for COVID. We are back trying cases here in Virginia. There was basically a 1-year hiatus and then a little bit of a delay because of the criminal cases got priority, but almost every circuit and court in Virginia is back to trying civil jury trials. I'm just going to highlight a few things I think you should know about Virginia's general court, trial court. They can hear matters from 4,500 higher. In Virginia, you do actually have to put an addendum with a number in it in your complaint. I know other states, some of them just say over 10,000, or they say an amount to be determined. You actually have to put a number in Virginia in your complaint. Of course, there's a liberal standard to amend even up to trial to increase the addendum. It's not a very high burden, if it's a burden at all. In Virginia, we call our motion to dismiss a demur, but is essentially the same standard as you're familiar with a motion to dismiss, which is failure to state a claim upon which relief can be granted. Now, there is a peculiar thing about Virginia summary judgment in state court, and it takes people back every now and then if they haven't been in Virginia before. But in state court in Virginia, the judges are not allowed to rely on deposition testimony to grant summary judgment. So you say, Joe, what do they rely on to grant summary judgment? Well, the short is they just typically don't grant summary judgment. Those type of arguments are really made in Virginia after the plaintiff rests during trial, during a motion to strike, and the judge has heard the testimony and seen the evidence at trial. There's two exceptions to this that actually newer exceptions in Virginia. One is you can rely on deposition testimony for punitive damage claims to move for summary judgment on those. And if the claims involve only business entities, so on both sides, plaintiff and defendants, and are over $50,000, you also are allowed to rely on depositions. In state courts in Virginia, trials are typically set 12 to 18 months out after service. Norfolk, Richmond, Fairfax are probably the highest volume courts, but they are also probably the most efficient. They typically want the trials done within 12 months, and they really do try to push those trials to be out of the courtroom by then. A couple things you need to know about the scheduling orders in Virginia, and just because we really do jam everything right before trial, it's unfortunate. We have discovery open until 30 days before trial. Plaintiffs disclose experts 90 days before trials. Defense disclose experts 60 days before trials. So, that's the time you're doing your motion practice. You might be doing a mock trial, trying to do a mediation. And, not to say just prepare for trial. You have all these things happening at once in Virginia. One recommendation I would have is in the catastrophic and the complex claims, you do yourself a favor, and typically experienced plaintiffs' attorneys will agree to this, to change the scheduling order to where discovery is being cut off maybe 60 days before trial, and the plaintiff's experts, instead of 90, are coming at least 120 before trial. So you're not jammed up in the end where you're trying to get the case resolved and trying to do mocks or just trying to prepare your case. One last thing about circuit courts in Virginia, jury trials. We typically have to have at least 7 jurors sit. In a bigger case, you'll have 2 alternatives sit with the jurors that can be excused, or by agreement by plaintiff and defense can go and render the decision on the case. You pick your 7 jurors of at least 13. The plaintiff's side and the defense side each get 3 strikes. There is an exception. If you sue for the GDC amount, you only have to sit 5 jurors, but that's not really going to happen in any of your cases. And one last thing in Virginia, I know not every state does this, but you have to be a unanimous verdict on liability and damages. There are no majority or split verdicts in Virginia at all. So everything has to be unanimous. And so that helps you in terms of sometimes the hung jury or more likely a compromise verdict. Okay, so that was the circuit courts. That's what you need to know there. Obviously, me and Bryn covered the highlights. You can go to our handout that has more and more details. But after circuit court,